Good morning, friends. As usual, this will be the first program of this year, 2022. Welcome you all, and thanks for your participation in this program. As usual, our intention is to share the knowledge, and we always prefer to have outsider experts who give inputs on the topic of practical experience knowledge. The intention is knowledge sharing. And today's topic is limited liability partnership. Honestly, I myself is always used to confused and worried because this law is not yet too explored as such. And there are so many structuring can be happening and it can be worked out. You take it from a legal angle or from taxation angle. And that's why even it's little confusion. When more freedom is given also, then you are little worried whether this will create problem for us. So today's topic of limited liability partnership, and we have with us one of our own moderator, Mr. Bala, as usual. And also we have with us Mr. Manish Malpani, practicing advocate, qualified chartered accountant. He has a total experience of 20 plus years and practicing in the field of real estate corporate matters in Pan India. And he is involved in legal aspect of limited liability partnerships. With his rich experience, he will give inputs on the legal aspect and structuring of LLP. Welcome, Mr. Manish, to Mehta Mehta webinar. We have with us Mr. Mehta. He is a practicing chartered accountant specialized in providing a wide spectrum of professional service under one roof to leading domestic multinational corporation, and is serving in the profession since last 35 long years, and his approach is always problem solving. Most difficult problems, he brings out the solution. So he will give us his inputs and expertise on the taxation aspect and structuring of LLP today. Welcome, Mr. Mehta to Mehta Mehta webinar. And I'll request Mr. Bala to give some introduction on the topic, and then Mr. Manish and Mr. Mitesh for some time, and then Keval, you can start the presentation. Over to Mr. Bala.
Good morning to all of you. I have a pleasure in welcoming you in the new year. Let me wish you a very happy and prosperous new year to all of you. The limited liability partnership, which has been actually there for the last 1 decade or so. The limited liability partnership actually a new form of the business, which will definitely is helping for the starting business here, because unlike we had earlier the traditional partnership firm where the partners' liabilities are unlimited. That means their personal assets can be attached in case of any liability to be met, etc. and all these things. Whereas the limited liability partnership is actually combined the aspects of a corporation and as well as taking care of the partnership aspects as well. Here what happens is, this is a better preferred form of the business to start with the business, and then later on as the business increases, you can actually get merged. It can be converted, it can be amalgamated as a companies, it can be amalgamated with a private company or public company, whatever it is, because there has been a recent case was also there in Madras High Court that amalgamation of the LLP, whether it can be done with the limited company. Yes, it can be done. A scheme has been actually approved. That was also there, which is the recent judgment. So in the case of the limited liability partnership, as we have seen, it is, number one, the partner can be unlimited. And that is why we see there are a lot of chartered accountant firm, legal firm, professional firms, even company secretaries firm, they are all forming the limited liability partnership. And as far as the complaints are concerned, it is really speaking not so much cumbersome compliance is the limited compliances, because we don't have to follow the secretarial standard here like a corporation, or again the board meeting and annual general meeting, etc. It's not there because it is mostly a partnership, but at the same time, it gives a preferred form of the business because it is on the MCA site, is available to the website. People can have a good visibility. And again, the partners have got a limited liability to the extent, so long as they are abiding by the rules. If there is anything which is done criminally, if there is anything done illegally, then there's a different matter. That is also, there is a provision is actually there. So with the result, the limited liability partnership nowadays actually becoming very popular, but at the same time, there are a lot of issues because limited liability partnership how can you actually get amalgamated, how can you do the reconstruction, how can you do the reorganization, all those issues are there. In the recent past, there have been couple of issues, there have been cases, and we have the renowned practicing people on the field. As Dipti actually pointed out, I think we'll have the benefit of them on this. And of course, the taxation, the limited liability partnership will be taxed as that of a company. That is, the companies are taxed today at the rate of 30%. The same thing will be applicable. So that what happens is the partner's income after the income, that is the way it actually works out. So I think as we go along, we will actually learn what are the benefit, how to form the limited liability partnership, what are the compliances which are required. So it will be a good form of the business. So over to Mr. Manish.
Thank you, sir. Thank you, Dipti ma'am. Welcome, everyone. As regards the LLP, there are very few legal judicial precedents which, according to my knowledge, have come as far as the litigations are concerned. And being an advocate in practice, I would be happy to get knowledge on the litigations in this subject of LLP. This being a hybrid form of partnership as well as a private limited company, has taken advantages of all partnership as well as the private limited companies. As time passes, we will be getting to know more and more legal aspects, and judgments will come as far as the Limited Liability Partnership Act and the litigations under that. With this, I without wasting time, would hand over to the other panelist, Mitesh sir, to take it forward.
Hello.
Yeah.
Hello. Is it audio is okay?
Yeah.
Okay. Now, since LLP, I'm just adding few words to what the other panelists said. That LLP is a new demon which has not been tested and fought in the court of law. But the most important subject which I've come across on many conversion of private limited companies into LLP, that most of the clients and SSE could not convert the names of the assets of the LLP from private limited to LLP's name. And hence they face a lot of problems when the assessments are going on the year in which the conversion take place. And many a times the assets are not converted, which is the condition of the conversion. And many a times the PAN, which is of private limited company, is not getting migrated to LLP, and hence the people just take a new LLP's PAN number. And there are a lot of confusion as far as the assessments are gone. So that is the most important aspect which I have come across as a difficulty which has not yet found any proper solution.
I can see Tanuja has raised the hand. Anything, Tanuja, you would like to say?
Miss Tanuja, you have raised the hand. Miss Simanti also raised the hand. Anything you want to say?
May I, Simantini here?
Yes.
Yeah, please.
Yeah, I just want to state that in my organization, I convert. Am I audible?
Yeah, very much.
Okay. I did finally ended up taking a new permanent PAN for the LLP, which I converted from private limited to the LLP. And the reason being, in the income tax department explained that why it cannot be converted or a name change cannot happen, because the way PAN is given in firm, in the middle, that letter comes F. And in PAN, the way they coin their structure, it is the company. So that you have to go for a new PAN. Like this answer I got from the income tax department.
Okay.
And that's why we ended up, we surrendered the PAN of private limited company and got a new PAN. Yeah, that's it.
It's a good input actually from you.
So you
Yes.
have taken a new PAN for LLP.
Yes, there were multiple applications. I chased it almost for 6 to 8 months. I thought it would be very simple process once I have, ROC, this thing on my hand that my LLP, from private to LLP, it is converted. But it's a ground level reality which I had to face at that time. So, and the reason they said the way tax department assess the firms is a different nomenclature, and that's why they couldn't do it. Means I didn't get anything in writing, but orally that officer confirmed.
Okay.
Yeah.
Then if that is taken, Mr. Manish, if you can give comment on the asset transfer, if your experience, as Mehta Mehta has mentioned, the issue of transferring the assets from the private limited to LLP.
Yes, so what is happening is, since there is a change of hand, and since there are no specific provisions for exemption under the local stamp law, I will discuss about the stamp laws first and then come to the land revenue code. As far as the Stamp Act is concerned, unless there is a specific exemption provided by virtue of the articles or by virtue of Section 9 notification by the state laws, any change of hand amounts to charging of stamp duty. There are judgments as far as partnership form converting into private limited companies are concerned, and practically down the line, ground level, there are a lot of challenges which are being faced because of non-clarity on this subject, and this subject being a state law, all the states interpret it in different fashion. And according to me, since there is no existence of both the entity at a given point of time, there is no applicability of stamp duty on such kind of conversion. However, we have faced practically problem where we have gone ahead for a mutation or transfer of name in the land record, and we have been told to pay complete stamp duty as on conveyance, treating this as a transfer. So my advice would be, in such cases, wherever we make an application for transfer, the authorities ask us to provide a copy of deed of transfer of assets. We should never execute a deed of transfer. We should always insist that based on the conversion certificate, my name should be recorded. And in case, based on the conversion certificate, if any levy of duty is imposed on us, then it can be litigated at higher level and it can be justified before the court of law. The moment we execute a deed of transfer, then we invite trouble, because in the deed of transfer, we have to show a transferor and the transferee entity. And then it falls within the clutches of levy of stamp duty and any local laws, if any. And as far as mutation exercise is concerned, for example, in Maharashtra, like 7/12 extract or property card, we can directly make an application based on the certificate of conversion and ask the authorities, the city survey officer or the talati, to record the name in the land record. And as far as societies are concerned, we can make application to the society for transfer of name in the share certificate.
So actually should be a change in the name in the record of the authority, rather than it's kind of a transfer, whereby the owner's name is changed. Owner is same, the name is changed. That way it should be, but it is always taken as a transfer by authorities.
Yes, and the reason for that, according to them, there is a change in the status of the entity. So from LLP to a company, or from company to an LLP, or from a partnership firm to an LLP. So since there is a change in status and there is no specific exemption, it is treated as a transfer and therefore charged as conveyance.
So these 2 points to be actually clarified, that one is that as regards PAN, even though you apply, income tax authority should clarify, you should apply separate PAN number, but it will not affect, refer your old PAN number, your status, taxability. If that would have been done, the clarity would have been there and the people will not face any, fear. And as regards stamp duty, this clarification is required at the central level, that it is same duty and state should not charge on transfer from entity, right?
Yes.
Ah,
And as far as the stamp
Revenue
duty is
collection.
concerned,
Hmm.
we have also made representation to the central government, and in turn center has written to the states also, but there is no call which has been taken by any of the state government so far.
Whatever money comes, take it.
Yeah, basically it is a
Yes.
revenue collection, nothing else.
Yeah, Mr.
Anything,
Mitesh,
they find out the value of avenue of collecting the money.
you're right.
In my experience, I have also seen private limited companies PAN being converted with the same PAN, but the status is converted to LLP. But that is very, very rarely. 3 cases only out of 100 cases has been converted in my own office. Out of all 97, we have applied for the new PAN.
Oh
So
my.
so there is no is concerned, and those are done in the early stages of LLP being introduced.
Right,
Yeah. After that, they've not given any PAN conversion.
right.
What about the employees? Employees of private limited company would continue as the employee of LLP from Gratuity Act point of view? Any inputs?
Hello.
Hello?
Mr. Manish?
Yeah. Sorry, I missed it. I think there was some network issue.
The
Yeah,
employees of a private company which gets converted into LLP, will they have a continuous status for gratuity and for all other benefits which a private limited company would be giving to those employees?
According to me, yes, it should be there. The previous period should be counted because there is no change of hand as such. The company's status has changed, and therefore the continuity of the previous period should be there. And
Because
if it has
normal,
not been, sorry.
Normally, any scheme, when you actually draft it, there will be a condition.
that
The
is what
employee's interest is
amalgamation
always
merger
to be
fine.
protected. So naturally,
Amalgamation,
yeah.
Amalgamation merger, I agree with you, sir, because there is very specific mention in the scheme itself, which is
Yeah.
accepted and the order is passed accordingly. But upon conversion of private into LLP, I don't know, it only, there may not be any clause like this.
But it should be. It should be.
It
Yeah.
should be.
Should be
Yeah, yeah.
principle of natural justice
Because it is
demands that
actually
there is
they'll-
no resignation of employee basically,
Correct.
or any
Unless the
transfer.
employee resign, that's a different matter. Otherwise, employee's interest always will be protected.
Yes.
This is the anomaly. I was telling that LLP is there, but it is not, the lot of points are not clarified. And that's why this problem is happening. They are allowing every conversion, but consequential problem and the situation, there is no clarity. We can,
Because the Income Tax Act, doesn't recognize LLP, it treats it as a partnership firm only.
right.
Correct, you are right.
So two government authorities, one treating as a partnership, the other one is a combination of private and partnership, which is, because we all are then facing practical difficulties.
Government and authority themselves are confused, so we are also confused. So what they
But
want.
the act is very clear as far as LLP Act is concerned. LLP is treated as a body corporate.
Right. But the authority is not clear, and the communication between government, central government and the state government and other authority is real a problem in reality to the actual public who face this.
Yes.
This actually situation.
May I add one suggestion to the gratuity this thing? While forming the LLP deed, when you are making a conversion, of course, you need a deed to run that LLP because LLP Act is very silent on many aspects. So
Right.
in that, if you could mention a clause clearly, the way we have a similar clause in our scheme of amalgamation, that the employees of this company will continue and protect interest of the employee, maybe that clause can act as a saver when you actually need it in front of authority. That continuity of employment remains. Anyone from the panel would like to comment on this suggestion?
You are
I
absolutely
think
right, because the
absolutely right,
LLB,
yeah.
what you call the deed, whatever we call it, LLB or deed or agreement, whatever it is, that is the governing document for the LLB, like a MOA and AOA in the company. Naturally, that document has got to be very, very carefully drafted, taking care of the current, future, whatever the requirement is there. Then definitely, as you rightly say, any litigation comes, the very first thing is they will refer that only. So that will actually solve most of the problem which comes out of the litigation. I agree with you 100%. The deed is required to be very, very carefully drafted. That is there.
What could be the reason of not closing an LLP within 1 year of its incorporation? Is there any specific reason? Because people say, I mean, you can't close it before 1 year from the date of its incorporation. What could be the reason? If there is no activity going on, then also you have to keep it for 1 year. Is it like that?
Even I don't know why it is. Actually, in my case, myself only wanted to change the name of LLP. And I was told that you cannot change the name of LLP till you file 1 year account. Then I say that, okay, fine, you file audited accounts. Then I say, okay, fine, I'll file the earlier audited account. Then you allow me change your no. Then you can't file that audited accounts also. That platform don't allow. So you have to wait for 1 year. Honestly, I tried to check with that authority, MCA. They have no answer. I said, why you are doing this?
My idea to this is, maybe as government machinery functions little slow, and to avoid any money laundering or this thing, they need that 1 year. That might be the idea, making it mandatory that you keep that structure on. Otherwise, it will be on, and if you allow them to shut it off in 6 months, it is very difficult for the government to actually trace where the money will go. Just my idea might be.
No, and I have heard this in the ministry
1
also.
year.
That would have been the reason behind this. It was the intention.
Right.
Diptiji, just asking on what you just said. If I also want to close after 1 year, even though my turnover is less than 5 lakhs and my share capital is also, partner's contribution is less than 1 lakh. If I want to close, do I need to file audited accounts before closure?
Yeah, they are asking audited account.
That's what now they want to create a trace at multiple levels, so that tomorrow, if anyone is trying to, real case of money laundering, so a trail is created at 3-4 level and then they can trace it. Might be the idea, my guess. I am not sure.
But in AOC 4, there is no option. They just ask if your turnover is above the limit or capital contribution is above the limit. There is no option to disclose for LLP forms to show that accounts are audited.
But you want to close, they will insist, because see, audited accounts required to be filed. So it's very clear, no change in the constitution, name, anything is allowed unless 1 year account is filed, audited.
Okay, so just that attachment will be the audited ones, but there is no way to mention that the attachment are the audited one.
Yeah. But they are insisting, I'm telling you that.
Okay.
In chat box, there is a question. If a partnership formed before converting to LLP, partnership deed required to have clause regarding conversion, and if yes, whether the PF deed to partnership form deed to be amended to that extent. Second, whether partnership form is required to be registered before conversion to LLP. Yes, only registered entity can be converted. If status of LLP is defunct, then whether it is required to be officially closed. Struck off. Who will take up, Mr. Bala, and Mr. Manish and Mitesh and anybody? Please, all the questions, please.
Partnership form before converting LLP, partnership is required to have the clause. Yes, definitely it is required. Actually, that is what earlier one of the participants were also saying. And I was also mentioning the deed has to mention all the possibilities. So in such a conversion, because LLPs can be converted, it can be amalgamated, it can be restructured. So
no,
in such
they
a
are telling Mr. Bala, partnership form did require a clause that it can be converted into LLP.
No, partnership form is not required. If all the partners give a consent, it can be done. It is not.
Right.
It is not.
Then second, it's their question is whether partnership form.
No, partnership form no.
No, partnership form required to be registered to be converted into LLP.
Yeah. Partnership only registered partnership firm has to be there.
Okay. If status of LLP is defunct, then whether it is required to be officially closed, struck off, it is governed by, okay, that our Companies Act compulsorily say.
Yeah. It is governed by the Companies Act. Naturally, it has to be.
Otherwise, LLP, it is not that. It is
Yeah.
ROC and it's on you.
Correct.
But if it is on, it will create unnecessary liability for you also. No?
Correct.
Every year filing and all that. If you miss that, then penalty and all that will be problem. Okay, I think we connect straight away. First time attended all question at a time only. Now we'll start the
Yes.
presentation.
Okay, just I had one question in continuation. That's why I'll ask first.
Yeah.
So for that struck off thing, even we have an LLP that we are looking for strike off or closure. Now it is incorporated only in August. Now if 1 year has to be maintained, so only 1 year of accounts is the condition or 1 year of existence is condition?
1 year account you will make it if you are in existence. Then you immediately file in 1 day, it's okay.
Okay, so even though I incorporated in August 21 and as soon as I file in March 21 my account, I can file for closure in April 21, even though 1 year of my existence is not completed.
Yeah, I hope so. At least.
I think it is 1 year from the date of existence.
Yeah,
Actually,
so
I
even my
think it is-
understanding is that
It will be 1 year from the date of incorporation. It will not be just in
March
August and
18
March.
is
It will
not
not
there.
be.
yeah, so I will have to file for next year as well because
Yeah,
in the
that's
mid-year
right.
also they will not
22
allow
also
me
you will have to
closure.
file it,
Yeah,
then
right.
you can close it.
Yeah,
Yeah, so my closure can only happen in 23.
correct.
Ideally.
Right.
Thank you.
Okay, I think now we can request Mr. Keval to start the presentation. Okay, Keval, start your presentation, please.
So, good morning, all of you. Today, my topic of discussion is LLP. So, I would like to welcome all the panelists, partners of Mehta and moderator and my colleagues to join the webinar on LLP. So, I would like to start the webinar by discussing what is LLP and how is existence started in India. So the limited liability partnership was enacted by the Parliament of India to introduce and legally sanction the concept of LLP in India. Unlike the general partnership in India, LLP is a body corporate and legal entity separate from its partners, have perpetual succession, and any change in the partner of LLP shall not affect the existence, right, or liability of the LLP. So in summary, I want to add that the Llp Act was enacted on 12 December 2008, and it gave the assent on 7th January 2009, and it commenced on 31st March 2009. And the LLP is governed by the Llp Act 2008 and LLP Rules 2009. In further slides, I will like to discuss the advantages of LLP and why anyone shall choose LLP over a firm or company. So anyone can tell me why anyone will choose LLP over firm or company.
Can you say yourself instead of our?
I'm audible?
Yeah. Keval?
Hello, am I audible?
Yeah, Keval.
You are audible.
Yes.
Okay, so I would like to discuss the advantages of LLP and why anyone should choose LLP over firm or company. So LLP is a separate legal identity and in LLP, where a partner is not liable for all the losses of the company, compared to partnership. In partnership, all the partners are liable for the losses of the company, and the partner of an LLP have the rights to manage the business directly. Uh, Unlike company in which the management is managed by directors, and members are different from the directors. So further, I'd like to add that the liability of LLP is limited to the contribution which is organized by LLP partners. And in company, we have more compliance, like we have to conduct AGM, we have to maintain statutory register. That is not the case in LLP. So you can focus mostly on business, not on the compliances part. Further, I like to discuss the difference between LLP and partnership form.
Keval,
So
there are more advantages on right hand side which you have not spoken. Just go to previous slide, please. That LLP can raise funds from partners, bank, NBFC.
oh yes, yes, and in partnership we have the limit of number of partners, but in case of LLP we can have a maximum partner, and there is no limitation in that. And in company we have like dividend distribution tax, and that is not the case in LLP. So LLP enjoys the flexibility of partnership firm and limited liability of company. So anyone will prefer LLP over firm or company to run their businesses, I feel.
If there is only one partner in LLP like company, they can also, this sole partner can find new one without dissolution, right?
Pardon, ma'am?
The second advantage on right hand side, that only one partner is left in the LLP, then that sole partner can find new one without dissolution, right?
No, we have to appoint a partner within 6 months
Right.
to run the LLP.
Yeah.
Can't have only one partner. So further, like to discuss some basic definitions like LLP agreement, what is contribution needed, and what is designated partner.
1 minute. In the one partner case, if the one partner is there, he can actually appoint another partner within a period of 6 months. That is what it is given. But if he continues the business beyond 6 months, the period, then what will happen is whatever the act he has done, and he will be personally liable for that extent. To that extent, his personal liability will be there.
Right. Unlimited liability.
Yeah. Right. Okay, go ahead.
Further, I will like to say that for tax purposes, the LLP is treated as firm. So liability is limited for other requirements. But for tax purposes, the liability of partners will be unlimited, I feel.
Could you repeat this point? I didn't get this. Liability of partners for tax purposes in LLP.
So for tax purpose, LLP is considered as same as partnership form. So in LLP, the liability of partner is limited subject to their contribution. But if for tax purpose, partners LLP is considered as partnership firm. So in partnership firm, the liability of partners are unlimited. So for tax purpose, liability of LLP partners will be unlimited. But for other statutory requirements, the liability will be limited to the contribution, I feel.
What do you feel?
I have a question on this. Maybe now or after you finish the presentation. Yeah.
1 minute. Keval, what you said last, repeat again.
Okay.
Liability.
The liability for tax purposes in partnership form is unlimited, and for the purpose of taxation, LLP is considered as partnership firm. So the liability will be unlimited for tax purposes. For other statutory requirements and purposes, the liability of LLP partners will be limited to
Okay,
their
okay.
contribution, I feel.
So like in private limited, in income tax provision is there that if the company is unable to pay the income tax, then the liability of director is unlimited of private limited company. So similarly, they have made that LLP partners liability to pay income tax if the LLP is unable to pay income tax unlimited. Okay, similar provision they have given to LLP also. Yeah, you can go ahead for question. Sorry.
Here, my question is, if the partner itself is a body corporate, okay, and there is a nominee of that body corporate, that you need a person ultimately. So body corporate can appoint, there is a provision can appoint a nominee. So with two body corporates being a partner in the LLP, when this situation arises, what you just said, that tax authority is taking a view that it is unlimited. How it goes, because I do have a structure where there are two foreign body corporates. They are being partners in an LLP, Indian LLP. The tax liability right now, it is very small scale, it's small and taxes are being paid, but considering the future, whether it will fall back on nominee, the person of that body corporate.
No body corporate.
No, it will be on the
It
body.
will get limited. It will be on the body corporate, right? So nominee, though is having a deep in, but is not an equal to a director in a private company. Is my understanding correct?
Yeah.
Yeah, absolutely, you are right, because the nominee is only a representation of the body corporate. The ultimate liability will be only on the body corporate, not with the nominee.
Perfect. Okay. Yeah. Well taken. Well noted. Thank you.
I'll move forward.
Yeah, please.
So further, I like to discuss some basic definition which are given in Llp Act 2008. So first, I like to discuss the definition of partner. So the definition of partner is given in section 2, subsection A in Llp Act 2008. It states that partner can be individual, body corporate, and company incorporate in India, and which is company incorporate outside India, and LLP which is also incorporate outside India. But here is a catch. In that it's given that HUF cannot be a partner or a designated partner in LLP.
You are absolutely right. HUF cannot be a partner in the partnership, but however, the karta of the HUF in his individual capacity, he can be as an individual.
So it will not be karta, no?
Yeah.
It will be individual only.
Yeah, it will be individual, not a HUF.
So you cannot say karta can be also.
No, karta in the sense he can be a karta in HUF, but in an individual capacity, he can be. That's what I'm saying. The individual capacity, he can be a partner, but as a HUF, he cannot.
Yeah.
Okay. So even a trust can be a partner in LLP now, right?
Yeah, that is right. Trust can be.
Earlier, it was not the case. I think they have amended.
Yeah, trust they have amended subsequently. Trust came actually later. When the LLP
after
Act
3-4 years of incorporation. Correct.
Yeah, subsequently it came.
Correct.
I'll further discuss definition of designated partner. So section 7 of LLP Act 2008 states the definition of designated partner. It states that only individual can be a designated partner in LLP, and minimum 2 designated partners is compulsory in LLP, out of which one should be a resident India, which should be staying in India for more than 120 days. And if any LLP is like having only body corporate or companies as LLP, then they can appoint a nominee as a designated partner, but any body corporate can't be a designated partner. Only individual can be a designated partner in LLP. So a person who is of unsound mind jurisdiction and who is undischarged insolvent and who has applied to be educated as an insolvent and his application is pending. So this all are can't be treated as partners in LLP. So this we have discussed already that designated partner will be only individual and at least one DP should be resident of India.
Designated partner are responsible for compliance. I have one question here. The is it necessary? Now we understand two designated minimum partner is required. Now, if I designate other person as only partner, not designated, my first question whether capital contribution from other partner is necessary to be a partner.
No, it's not necessary, but we have that one flaw in MCA that they don't accept the form without contribution. So we have to put the contribution amount like we can say 10 or 100 because in practical aspect, if I discuss, the MCA form that does not allow to incorporate the LLP without having contribution. So this is the one major flaw I feel in MCA forms.
So the
Yeah,
sorry,
please.
Dipti, yeah, please go ahead.
No, I wanted that, but why it is like that way? Because if I am having designated partner who are contributing, so I have some other understanding whether that other partner can be partner other individual without contribution.
No, but then what will happen to his or her share of profit? Will he get the share of profit without contribution?
No, no share of profit, but they agree to provide service to each other.
Okay.
I
So
feel
contribution you are saying could be zero for a partner
Right.
and
Manisha,
without profit
your
sharing.
experience or your inputs on this?
I feel it's all depend upon LLP agreement as well. If we can state in LLP agreement that the contribution part, then it's okay because LLP is governed by LLP agreement. So if we
No,
state
agreed. But what she is saying, when you fill up the form, if the contribution mention is zero, whether it will go through the process of filing the form, because as
I think it should actually go through, but I do not have the practical aspect on that. Because what happens is, when you talk about a person, we can actually have a working partner with no contributions.
Exactly. That is the beauty
Because
of
capital
LLP.
is contributed by others, and we have a working partner who actually manage the LLP. Okay, so still he can receive the share of profits. I don't see there should be any problem. I think in the practical aspect, amount filling if zero is also an amount. I think it should go through.
It should go through. And secondly, suppose the contribution is not in cash. Say, for example, it is in some kind of a property which is given to that LLP to use it. It's a contribution by that partner. Okay, I will bring it in kind, not in cash. Then what amount will be filled up in that form? Zero. So it should go through, according to me.
yeah, it's
But it is
allowed.
honestly
So if
speaking
there
in
is an
MCA, it is not going. So that's why question I was myself was wondering that not necessarily every time you bring a contribution in kind also, like property, you also share your rights or you say that commitment that I will take your services if you make me partner. Like for example, in my own case, we have insolvency entity and we are making partners. So I want to show them as a partner, but they will not get profit or contribution. They are not contributing, but they will provide me that as and when they are anywhere appointed, they will take the services of my
No, in which case I think what you should do, according to me, earlier we used to have a concept in the companies much longer in 1956 Act. The director should have the qualification shares. Normally, if there are two people who are forming from the some 100 rupees or something, a nominal, share is to be allotted to them. I think in the partnership, if that is the case, a nominal value of 1 rupee or 10 rupee, that should be filled up. That's all. I think so.
The same thing, but why it should be when they are telling that can be, that is the main structuring that, you are allowed you. So that means they are partner, but they are not recorded anywhere. So you have not to show and file anything with MCA for that. that way.
I agree with you, but some or there is a system requirement. They built it that way. That's all it appears to be.
Because I checked with MCA that why you are insisting contribution.
Hmm.
In agreement, we are writing that what is the consideration. I agree for the contract validity. You require a consideration on both the part, why you are entering into contract. It's a contract. So I am writing in agreement that what is the consideration for me to include that person as a partner, and what is the consideration for that partner to be a partner. So that is a partnership, but I cannot value it as on today. So in that case, why I should you insist for a contribution, allow that to be added as a partner. So far, designated partner is contributing total contribution.
Like, for example, you may give your office premises for the use of the LLP's business, which is a in kind you have given. It's a contribution by you.
Yeah, so it is not happening, and that's why I'm telling they have said that it is to be explored and it can be explored, but as regards when actual implementation, they are not having idea how it can be explored, and they are always scared that something will be wrong, something will be wrong. So that's why even I am facing this. So I am also checking. So I thought if anyone has done and has idea, but I think I have to give contribution, or I have to just show them as a partner, but not to refer in partnership date. So one of the question is also that there is no limit in the partner. So in that case, we keep on adding the partner anytime. And every time we have to change that partnership date. If we say that add the partner, then you are asking contribution. Manish bhai, you have any idea on this part?
My early days of practice as a CA, I have faced these similar issues, and I was told upon approach to ministry that it will be tackled and it will be taken care of. Last 7-8 years, I have not in touch with the formation of LLP. But yes, initially we had to write 0.001% or a minimal amount of contribution to take as a designated partner. Although the Act does not provides for it, or there is no compulsion like holding of any qualification shares or any specific percentage by the designated partner.
No, I am telling designated partner is contributing, other partner.
Okay.
Other
There I
partner.
don't have any practical exposure.
Because then in that case, why you require? That is the point. Any participant has faced anything, this kind of thing?
That is what mandatorily law does not require anything, but practically when you go, you face a problem.
Yeah, exactly. That is happening.
Yeah.
So it is said that maximum partner. So if you say that partner, so every time you add and everyone has to contribute in that case, or otherwise you put a partner, but it's like a officially you are allowing that you don't add them partner, but you call them partner. Because I don't want all partner to contribute. So otherwise they are telling indirectly that whether designated or otherwise partner, they have to bring the contribution in cash or kind. You have to value it. It can be termed it that way as on today.
Yeah, because of the system, you can say that. But mandatorily, it is not actually.
Yeah. So Act and the form is not matching.
Correct.
So as on today, if I want to add the partners, so I have to add in the partnership deed. I have to change the partnership deed every time. I have to take minimum contribution from them, and then only I can make them partner.
Yeah, you are giving a practical way.
This is I'm facing actually. That's why, and I said why I should be. They are partner. They want to be partner. Then this is the problem. And again, that Keval, you have taken removal of partner in this presentation, or we'll take it later. Go ahead, please.
Further, I'd like to add one point. The section 32 of LLP Act 2008 states the form in which contribution can be brought. Kind also contribution is allowed. So if any contribution is in any kind, then we can have a valuation report for that, and we can attach that at the
That
time
is
of
mentioned, valuation, and yeah, it can be
incorporation.
in time.
So it will do. I think so.
Yeah, that is there. It
Yeah.
can be.
So further, I like to add one more topic that is recently introduced. That is small LLP. So it was recently introduced in amendment that small LLP is a partnership. It's an LLP which is other prescribed limit and which cannot be more than 5 crore, or turnover which does not exceed 40 lakh, and or maybe prescribed with the to form. I feel. So
Even you are not
I'll move
audible.
forward with the incorp.
Yeah, now please keep your mic properly. Kevin, you are not audible on the last part, small LLP.
Audible? Okay. Now I am audible.
Yeah,
Okay, I'll repeat the topic of small
yeah.
LLP. So it has been recently introduced in LLP Amendment Act. So it states that small LLP can be formed by having contribution not less than 25 lakh rupees, or maybe prescribed which does not exceed 5 crore rupees, and or turnover of having no lakhs or prescribed amount which can't be exceed 50 crore. So this is how we can incorporate a LLP. So non-professional to start LLP, I feel. Am I audible?
There is a problem. You start, but
There is a problem. Some audio problem is there.
Now I'm audible.
Yeah, now.
Okay. So shall I repeat the topic or shall
Yes,
I
yes.
move forward?
move forward now.
Move forward.
Okay, okay. So now I like to start the topic of incorporation of LLP. So how do we incorporate the LLPs? There are 5 basic steps from which we can incorporate an LLP. To form an LLP, I feel it requires only 10 days. In 10 days, we can actually incorporate a LLP. So first step is to obtain DAC. So we have to obtain the DAC of all the partners, majorly for designated partners, because it will require the sign of and certification of a designated partner on all the important documents in form which are to be filed with ROC. So second is to apply for DIN. So we have to apply for the DIN at the time of incorporation. For only two documents are required. So third step is name approval. We have to apply for name of LLP. So we can application form, or otherwise we can directly apply in form filling. So the cost of run application is 1,000, and we can apply 2 names via run application. But if we are filing name application in Philip form, only one proposed name is allowed. LLP. So we have to attach the required documents in the form Philip, and after that ROC will give the certificate of incorporation. And after incorporation of LLP, within 30 days we have to file LLP agreement with ROC. So this is how we can incorporate a LLP.
Yeah, go ahead.
Okay, so I'll now like to discuss about LLP agreement. What is LLP agreement? So the definition of LLP agreement is given in section 2, subsection O of LLP Act 2008. It states that it's an agreement between the partners and LLP. It decides the mutual rights and duties of partners. So, like how company is governed by MOA and AOA, so LLP is governed and run by LLP agreement. So it's establish the right and duty of the as well as towards the LLP. So like it's the easy guide that gives a direction to run the LLP. So further, I like to discuss if we can change the LLP clause or capital contribution by the partners. So we can change the LLP clause, management structures, terms and condition by filing revised agreement in form 3. So we can revise the LLP agreement. Okay. So further, I will like to discuss the stamp duty on
Go to
LLP
previous
agreement.
slide, previous slide.
Yes, ma'am.
Change in a business activity, change in the LLP clause, change in capital contribution, by the partner, modification of right and liability, profit sharing, terms, conditions, management structure. So in that case, LLP agreement should include all these clauses basically.
Yeah, for change in any clauses of the agreement, the clause should be mentioned in LLP agreement.
Any compulsory requirement of LLP agreement that these all should be surely part of LLP agreement as per the require act, LLP Act or rules regulation.
Can you pardon, ma'am?
In LLP agreement, is there any specific provision that these are the items should be there in LLP agreement compulsorily?
Uh, so we have to include this basic clause to run the LLP, and if something is not given in LLP agreement, which are like mutually decided by partners, so they can refer the first schedule, which is given in the LLP Act.
So it should be so far possible as per schedule, right?
Yeah.
Okay, go next.
So further, I like to discuss the stamp duty on LLP agreement. So stamp duty is subject to state law. So the stamp duty on LLP agreement is updated as per the Finance Act 2009 and respective Stamp Act. So for all the state, it's a different. So it depends upon the contribution which partners are bringing in LLP. So for like up to rupees 1 lakh, the stamp duty is different. And for contribution amount to rupees 1 lakh to between 5 lakh is different. And from for 5 lakh to 10 lakh is different, and more than 10 lakh it's different. As far as Maharashtra is concerned, the stamp duty for Maharashtra is 1% of capital or minimum 500. For example, if stamp duty comes 200, but for minimum we have to pay 500 stamp duty if the contribution is up to 1 lakh, and maximum stamp duty you can pay is 15,000. Okay, further I like to discuss
Manish,
to
you
discuss
wanted to comment on stamp duty. Is that
the clauses of
better?
LLP agreement.
No, not as of now. Let him finish. Then if there
Okay,
are any
okay,
queries.
okay. Yeah, Keval, go ahead.
Oh, okay, I'll start now. The clauses of LLP agreement. So this clauses should be mentioned like name of the LLP, date of the
I think there is some
agreement
voice problem is
and
there. I don't know.
Some problem is there, I know. I'll just check it.
Yeah,
You
voice
carry on,
problem is
Keval.
there.
yeah. So other clauses of LLP agreement are business activity, duration, accounting and auditing, and partners contribution and method of contribution. Okay, further I was discussing clauses of LLP agreement which has to be there in any LLP agreement. So like basic clauses like partners, disassociation of partners, partners rights to records, management and fiduciary duty, and if any conflicts arise between partner, then where should they go for solving their issue? Then if no such clauses mentioned in LLP agreement, they can go to arbitrator, which is mentioned in Arbitrator and Conciliation Act 1996. So further, I'd like to discuss the post-compliance checklist for LLP.
1 minute.
So in company, if we apply for
1 minute, Keval. The LLB
yes,
agreement
sir.
is being a document which is actually the fundamental document to the LLB. It need to be very, very carefully to be drafted. Probably before drafting the LLB agreement, it is better to take a expert advice like a practicing company secretary, chartered accountants, other relevant people in the field. Because if anything is missing in the LLB agreement, then we will end up in the longer litigations and matters are not cleared and the interpretation issues, all those things will come. So as far as possible, the LLB agreement need to be very, very carefully taking into consideration what are the possible future thing, what can happen, what is the thing, all those things need to be very, very carefully drafted. And here I think the practicing people from chartered accountant, company secretaries, and other fraternity, they can contribute to a greater extent. So that is a very important of the LLB agreement I would like to say here. Yeah. Go ahead, Akil.
So if we incorporate a company, am I audible?
Yeah, you are audible.
Okay, if we incorporate a company, then in incorporation itself we get a PAN and TEN, but it's not the case in LLP. So we have to separately apply for PAN and TEN of LLP. So other compliances which has to be done after the incorporation is we have to file the form, open a bank account in the name of LLP with the name of
Now, Mr. Bala, I have a question. Suppose the body corporate is a partner in LLP. By the time Deepti Ben is able to set the new instrument, I thought just rather than wasting our time.
Sure.
Okay. Now, suppose there is a Private Limited, which is a partner in LLP.
Yeah.
There is a director who is a DP.
Yeah.
Okay. Now, the director becomes disqualified.
Yeah.
Then he automatically also ceases to be the DP of this LLP.
Yeah, naturally. Naturally.
So it goes without saying, right?
Yeah, that's right.
Okay.
Because here also, if you want to have a designated partner, you need to have a designated partnership ID, or you need to have the director's ID. Any one of the things you should have actually.
Correct.
So once he becomes a disqualified, then again, he cannot act in any of his capacity. That is the thing. Yeah.
And this LLP can purchase the agricultural land?
As a contract, yes, but whether agricultural land can be, the question will be, if agricultural land can be purchased by a company, then it can be purchased by LLP. But that is the point I will put that with. I am not sure whether a company can own agricultural land. That is a different angle because that farmer status and all that. But
Correct.
land can be purchased for office premises and all that, yes.
Agricultural land itself, I don't think can be purchased, but the thing is, agricultural land, if it is, as Dipti puts it, if it is converted to the industrial use, etc., and other thing and all, yes, but subject to getting the no objection certificate for the conversion, then only they can do it. Yeah.
So first and foremost thing is to purchase by agricultural land by a farmer. Then it can be converted into NA.
Yeah, he has to get a conversion. Then he
Then it
can
That is
can
actually.
a
Correct.
different angle. The farmer will become a designated partner of Llp, and then whether he can own that, it is an angle of that agricultural status. Means
Correct.
it's
Correct.
Llp we can say, but I don't know what about the agricultural land, that ownership, criteria thing, whether they will recognize all the designated partner and all the partnership, all the partner of Llp are farmer. Whether then that Llp can own, again, it's a question, honestly. But per se Llp, yes. But from that angle of the compliance of ownership of agricultural land, we don't know the compliance. Yeah, Keval is
Thank you.
on the line now.
Yes. I'm audible.
Yeah.
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 Okay, sorry for the inconvenience caused. I would like to move forward with e-form filings which are required to be filed with ROC for LLP. So for incorporation, we have to file Form Philip, and after that we have to file Form 3 within 30 days of incorporation of LLP. Now, if there is a notice of appointment, cessation, or change in name, address, and designation of designated partner or partner needs to be changed, then we have to file Form 4. But for filing Form 4, we need to also change the LLP agreement as well, because the clauses are mentioned in LLP agreement. So we have to file the supplementary agreement as well if we want to change the any details of designated partner. So then if we want to change the name of LLP, then we have to provide a notice to ROC in Form 5. And there are two main forms which are to be filed with LLP is Form 8 and Form 11. So the due date of Form 11, which is annual return, is within 60 days of closure of financial year, which is 30th May. And the due date for Form 8 is 30th October, which is 6 months from the end of closure of financial year. So now if you want to change the place of registered office, we have to file Form 15 with ROC. So these are the other forms which has to be filed with ROC. If we want to convert a form into LLP, then we need to file Form 17 with ROC. And then if we want to change the company conversion of private company or unlisted company into LLP, we have to file Form 18. And another form for if you want to strike off the LLP, we have to file the Form 24. Now we can only apply for DIN of two partners at the time of incorporation. Now, if you want to appoint any partner, additional partner or designated partner, then we have to apply for the DIN and we have to file Form DIR3 again. And if you want to change in particulars of directors, then we have to file Form DIR6. So these are the e-form filings which has to be filed with ROC.
I think you have to add this charge also. Charge if it is created by LLP. If any loan is taken, then the charge form has to be filed with ROC, right?
Yes, I believe it has to be filed with Form 8.
Okay.
Only one thing here is the designated partners will be definitely responsible for all the compliances.
Yes.
The purpose of designated partners is they have to ensure the required compliances. They will be wholly responsible for any compliances relating to the partnership form. That is the importance of the designated partners.
Can this LLP be converted into one-person company, OPC?
Statutorily, it
Possible.
can be, but practically we have not tested.
Okay.
Because now in that case, they give, all the partner will give that and they resign and they agree to turn into one-person company. Because there will be two designated partners.
Correct.
So again, it done deed agreement and all that practically.
It's possible to do it, but then
Legally,
maybe-
yes,
It is possible.
practically.
Practical aspects, I don't think, unless anybody has got an experience here.
correct.
And I think it's not advisable to convert also, because that's the beauty of LLP, that we can focus more on businesses and less on compliances.
No,
If
but
we-
suppose there is some requirement that the partners are not gelling well with each other. And one person can say, okay, I am taking over all the business of LLP and I convert that into one person per company, you know. So the idea is whether it is possible, as Mr. Bala said, theoretically, yes, practically,
Yeah,
unless
that is
somebody
it.
has done it.
Yeah.
Actually, I'm observing that, the law has thought of allowing partnership form into LLP. They are not so keen or thought of, though allowing or not prohibited, of conversion of LLP into private limited and all that. Because they are looking both the format quite differently. So that's why practically, if you observe that conversion of partnership form into LLP is comparatively, they have provided, arrangement and some clarity. But about LLP to private limited, there is a lot of issues. Yeah, Kevin.
Okay. Further, I'd like to discuss the taxation aspect of LLP. So the LLP Act 2008 is silent on the taxation aspect. So, but it states that the Income Tax Act, Section 2, subsection 23 state that for the purpose.
Yeah, 1 minute. Kevin, you have taken a removal of partners in this LLP.
No, I haven't.
Is there any provision for removal?
I have to refer the act.
Okay. Mr. Bala, your inputs on removal, because there is one question in the chat box that what is the difference between expulsion and removal in case of partnership from partners?
I think it will be governed as per what is mentioned in the LLP agreement and
It
the
will be as per
expulsion
the
clause.
LLP agreement, because
Correct.
the thing is normally, that's what I said in the beginning also.
Very
Because
important document.
in case of any partner not acting in the interest of the LLP, etc., then the LLP agreement should actually provide that the other partners, if it is a case of the contravention of the act against the LLP, etc., they can have the right to removal. That clause has got to be there.
It has to be there as an expulsion and also as a retirement of the partner.
Yeah.
These two are very separate and very critical to be formed part of the
Correct.
LLP agreement.
So LLP agreement, it has to be there. You have to put it as a precaution so that it can be easily done. Otherwise, you will unnecessarily invite the litigations.
So there is no specific provision, but you can add in the agreement and create.
Yeah, you can do that. You can actually amend the agreement. You can again file the agreement. You can do that.
Okay.
Yeah, that can be done.
Okay. Okay, Keval, go ahead.
Okay, so I would like to discuss that as per section 2 subsection 23 of Income Tax Act 1961, the form includes LLP. So for the purpose of taxation, the taxes which are levied on partnership form will also be levied on LLP. So as per Income Tax Act, the taxation is in the hand of entity and exempt from tax to partner. So the same will apply in case of LLP.
Just suppose LLP gives loan to a partner. The partner is holding more than 10%, whether 222E dim dividend will come in play, because the partnership firm and the private limited or limited company comes in play, the 222E dim dividend. Same question can come here in LLP as well. Any inputs?
Because the question here is LLP cannot declare dividend.
No, no, LLP giving a loan to a partner.
Correct, correct. Because the question is, you are raised a very valid question of the deemed dividend.
Correct.
Correct, because deemed dividend is there in the Companies Act and in the Income Tax Act actually, which is happening applicable in case of the companies. Whereas in
Okay.
LLP,
There is
they are
no
not
question of
actually-
dividend.
yeah,
Correct.
they are not
correct, correct.
declaring any dividend.
So no bas na baje basuri kind of a thing. No dividend, no deemed dividend.
Correct, correct.
Agreed,
That is-
agreed,
yeah, that's
agreed.
it. Yeah.
Thank you.
Okay,
Yes, yes.
Mitesh bhai, you have any practical experience of this?
Yes, I was about to raise my hand.
Yeah,
Since in the case of partnership, I mean LLP, there is absolutely no chance and no scope of deemed dividend at all, as Professor Saab rightly said, because partners can easily withdraw capital only in case of conversion for 3 years, 5 years. There is a restriction. After that, there is absolutely no problem. And then there cannot be any scope of deemed dividend section apply. 222E will not apply ever in the case of LLP.
correct.
You mentioned about some 3 year, 5 year. What it is? Can you clarify?
That is when private limited company is converted into LLP, there is a restriction under income tax that partners cannot withdraw capital and profit as on the date of conversion. So if they withdraw, that conversion itself becomes taxable. So
Okay.
having that condition in mind, there is no other condition that partner.
Yeah, correct. There is a restriction in withdrawing the capital contribution by them for a
Yes.
particular period.
If I am not wrong, there is a
That is it.
section in the Income Tax Act where for 5 years, these partners who become the shareholder have to continue holding their holding. Should not drop
Yes.
less than 50. I think 44 section or 42 section of IT income tax.
That is section 47.
47.
Voice is breaking.
Yeah.
47.
Okay.
There are 5 conditions which we have to satisfy.
Correct. Correct.
Yes.
Then only the transfer, I mean the transfer is non-taxable. That's 47, 30,
3 or
13,
13,
yes,
3
yes.
C or something like that.
13B, there are 5
B.
conditions.
Correct. One of them is
For the
this.
general benefit, I don't mind repeating in short that first condition is all the assets and liabilities of
Right.
the company shall become the assets and liabilities of the LLP. In my practical experience, everybody fumbles in this compliance because mutual funds doesn't get transferred to LLP so easily. All the other assets doesn't get transferred so easily. As advocates have rightly said, there's a question of stamp duty. So that a lot of people doesn't do that. Let it be, they all remain to be in the hands of private limited company. And we face a lot of problems at the time of assessment, especially in the year of conversion. Second condition is all the shareholders of the company become the partners of the LLP. Third is shareholders do not receive any consideration or benefit directly or indirectly in any form or any manner other than by way of share of profit from the LLP. Fourth is aggregate shareholding ratio should be in limited partnership shall not be less than 50% for 5 years, as the queries rightly said, 5 years from the date of conversion. And total sales and turnover should be less than 60 lakhs. Then only you can convert private limited company into LLP. And the last is the total value of assets as appearing in the books of accounts of the company should not exceed 5 crores in last 3 preceding years. Then and then only transfer of private limited company into LLP is tax exempt. Otherwise, the entire conversion is taxable.
Okay.
Yeah.
Okay. Got it. Yeah, Keval, go ahead.
Further, I'd like to add one more point of capital gain. In general, if we transfer asset or something, capital gain is come into the picture. But for this purpose for conversion, it is exempt. But the condition which just recently sir explained, if that condition are not followed, then capital gain will be charged to the SSCIP.
Okay.
So further, I'd like to discuss the taxation of LLP. The tax rate for the financial year 21-22, which is the assessment year 22-23, the tax rate applicable to LLP is 30%. And the surcharge, if the total taxable income of the LLP is more than 1 crore, surcharge of at the rate 12% is applicable. And health and education cess is also applicable. Further, earlier it was 3%. Now it has been amended to 4%. So the amount of income tax and the applicable surcharge shall be further increased by health and education cess 4%. So the effective taxable income, if income is up to 1 crore, the tax rate applicable is 31.2%, and the taxable income is if more than 1 crore, then the tax will be 34.944%.
Oh, okay.
Okay, further, I'd like to discuss section 64 of LLP Act, which states the
Keval, 1 minute. There is one question in the chat box where we were talking about removal expulsion. Mr. Bala, in chat box, somebody has put that, in their case, that it is mentioned, Mr. Shiv Kumar, that partner was removed in an LLP as per Llp agreement. ROC Mumbai has rejected the form. Upon inquiry, ROC has asked to get a court order for such removal. Is this rejection appropriate? Manish bhai, anything in case law you have referred this way?
No, not as of now.
Okay. Actually, what is, according to me, it is observed that even nowadays, removal of directors, they are not approving the form often immediately. They are asking, calling all the details, convincing themselves, and then only removing removal of directors, because all removal of director is subject to litigation. So
Yes, many matters are pending in NCLT also.
yeah, so in reality, this MCA office, ROC office is not accepting removal of directors form also. According to me, similar line, though removal is actually the provision in the Act, Companies Act. This is a private agreement or contract between partners on the basis of which this removal is happening. So I think that that's why they are making this issue, and they are not removing and giving effect to removal. Because in private limited company, when there is a clear cut provision, they are scared because a lot of litigations are there and it's an instruction them. So in LLP, when this removal is due to the agreement between the parties only, they don't want to take a chance, and that's why I think they are telling that it is a court order, better you bring it before giving effect.
No, but Diptiban, in that case, if the partner is doing some mischief or is misrepresenting,
I fully agree.
then what will happen till the time you get the court order? As we know, the jurisdiction in India, I mean,
I
judiciary.
know.
But there is a section under 100 which Companies Act, even Z Entertainment latest just 3-4 months back. There is a provision in the Company Act for removal of a director under section 100, isn't it?
Yeah, it is there. It is very much there.
I told you in Companies Act there is a provision still there.
But then still they are asking for Companies Act is providing. Then also they are asking
Yeah,
for
because
They ask us to comply with the act strictly, like notice has to be given. Many times the notices are not properly served on the director. So that comes heavily upon the current management then.
So correct. So if the procedural part is done very thoroughly and completely in all respects, giving an opportunity to the other party as a director to give a representation and all that, it should not be a problem for removing a
yeah,
director.
but they are asking, calling the people and checking everything, that dispute is not there and kind of thing, they are precautionary. Similar way, according to me, in this LLP they are doing, but it can be questionable that, why it is contract. But again, to do file that litigation, meanwhile there are damages already done.
Yeah.
Correct, you are right. As you said in the beginning, there are a lot of if and buts. As we go along, only we actually experience the practical seems to be something different than what it is actually written in the Act.
Yeah. Okay, please go ahead, Keval.
Okay, further I'd like to discuss the section 54 of LLP Act 2008, which states the circumstances in which LLP may be wound up by tribunal. So wound up can be happening in two parts, voluntary winding up and compulsory winding up. So if LLP wants to voluntary winding up, it has a condition that when partners of LLP mutually decide, so consent of all the partner is required for voluntary winding up. And second part is compulsory winding up. There are 4 conditions which has to be satisfied for compulsory winding up by tribunal. If first is if number of partners fall below 2 for more than 6 months, then tribunal may ask company for compulsory winding up. Second point is if LLP has acted against the interest of the sovereignty and integrity of India. The third point is if company has made default in filing for more than consecutive 5 years, the form 8 and form 11, which is for annual return, if we have not filed for more than 5 years consecutively, then tribunal may wound up that LLP. The fourth point is if a LLP has not carried on any business or operation for a period of 1 year or more, the registrar or LLP can initiate process for removal of LLP name from the register. So that LLP may be called defunct LLP if it's not carried a business for more than 1 year or more. In these 4 cases, tribunal may ask LLP to wind up.
In number 3, as you are mentioning, default in filing for more than 5, is it and or form 8 and form 11 or form 8 or form 11 or both? I mean, is it and or?
I feel both annual return
And it should be and.
policy.
Okay.
Yeah, both should be filed.
Both
If
should not
not
have been
filed,
okay.
if both forms are not filed for more than 5 years consecutively, then tribunal may ask LLP to wind up.
Okay.
Further, I'd like to discuss.
And of course, under IBC also, if you default, since LLP is also governed under Insolvency Bankruptcy Code, then creditors can take action and file, and even LLP do default, it itself can file.
Yes, correct.
So it will be under Insolvency Bankruptcy Code.
Yes. So further, I'd like to discuss the conversion of company into LLP. So the section 56 of Llp Act 2008 governs the conversion of company into LLP. So there are the 2 preconditions which has to be satisfied by a company to convert into LLP. So the first one is there is no security interest in its assets subsisting in or in force at the time of application. So like if any charge is created against any asset of the company, then we have to satisfy that charge before the conversion of company into LLP. And the second point is the partner of the LLP to which it converts comprises all the shareholder of the company and no one else. So for example, there are 3 partners, there are 3 members in company and they want to convert in LLP. Then if they cannot convert if one of the members doesn't have a consent, for that they have to first resign from that post and then they can convert. So this is the condition given, like the partners of the LLP to which it converts comprises all the shareholder of the company and no one else. So if one doesn't want the conversion, then before conversion, that person has to resign.
Means we will make him to resign. He cannot resign. Okay. Yeah, next.
So further, I'd like to discuss the process for conversion of company into LLP. So firstly, we have to call for board meeting and pass board resolution for the conversion of company into LLP. Then afterwards, we have to take the written consent of all the shareholder for conversion of company into LLP. So third point is to file the application for name availability in web-based form run LLP with ROC. So we have to attach the board resolution and propose object clause with the name availability application. And the fourth point is once the name is approved by ROC, we have to execute all the necessary documents like consent letter, subscriber sheet, and file form Philip and form 18 with ROC for the conversion. So these are the attachment for form 18 for the conversion of company into LLP. So first is statement containing consent of all the shareholders. So we will be requiring the consent of all the shareholders for the conversion of companies into LLP. So second point is statement of asset and liability of the company duly certified as true and correct by a certified auditor like a CA or advocate or a CM. So the third point is list of all secured creditors, if any, along with their consent to the conversion. The consent of all the secured creditors will also be required for conversion. And the fourth is acknowledgement of latest income tax return. These are the attachment we need to file with Form 18 for the conversion of companies into LLP. So further, I like to discuss a voluntary winding up. So compulsory winding up is given in the Llp Act. So, and voluntary winding up is covered in IBC Code 2016. So it states that Section 59 of IBC states that a corporate person who intends to liquidate itself voluntarily has not committed any default may initiate voluntary liquidation proceedings under the provision of this chapter. So for in IBC, the definition of corporate person is given. So it includes company registered under the Companies Act 2013 and includes under company incorporated under previous company law and a LLP registered under the Llp Act 2008. So it clearly states that if any LLP wants to voluntarily winding up, then they have to fulfill the procedure prescribed in IBC Code 2016. Any queries?
No, you go ahead.
Okay, further I like to discuss the steps involved in the process of voluntary liquidation. So firstly, we have to get the declaration of solvency. So declaration of solvency shall be accompanied by the audited financial statements and record of business operation of the corporate person for the previous 2 years or the period since its incorporation, whichever is later, and the report of valuation of asset of corporate person, if any, prepared by registered valuer. And third is we have to pass a resolution which shall be passed by majority of the partners of corporate person for voluntary liquidation and appointing an insolvency professional to act as liquidator within 4 weeks of obtaining the declaration. And the fourth point is in case the LLP owes debt to any person, so creditor representing 2/3 in value of the debt of the corporate person shall also approve the resolution passed under the subclause C within 7 days of such resolution. So this is the process involved in voluntary liquidation of LLP, which has been prescribed in IBC code. Further, I would like to discuss the strikeoff of LLP. So the strikeoff of LLP is governed by Rule 37(1) of LLP Rule 2017. So there are 2 modes of striking off of LLP, which are as follows. First is voluntary strike-off and second is mandatory strike-off. So voluntary strike-off happens when LLP is not carrying any business from past 1 year. And mandatory strike-off happens when a notice issued by register when LLP is not carrying any businesses from past 2 years. Now further, I'd like to discuss the process to strike off of LLP. So first we have to call the meeting of all the partners and we want the consent of all the partners. Then afterwards we have to cease the commercial activities of LLP. Then we have to close the bank account of LLP. Then after that we have to put the affidavits of all the partners and declarations. After that, we have to file the application with register in Form 24. And after confirmation by register, we have to intimate the ROC within 30 days that our LLP has been strike off. Okay, now further I like to add the provisions for facilitating reconstruction or amalgamation of LLP. So section 60 to 62 of Llp Act 2008 deal with the amalgamation of LLP. It is as similar to amalgamation of companies, which is prescribed in section 230 to 232 of Companies Act 2013. So it states that when an application is made to the tribunal under section 60 for sanctioning of a compromise or arrangement proposed between an LLP and any such person as I mentioned in that section. So it states a compromise or arrangement has been proposed for the purpose of or in connection with a scheme of reconstruction of LLP or LLP partnership or amalgamation of any two or more LLP. So under this scheme, the whole or any part of the undertaking, property or liabilities of LLP concerned in the scheme in this section referred to as transferor LLP is to be transferred to the another LLP. Okay, further I'd like to discuss the case law regarding if a merger of two LLPs is allowed or not, or if merger of a company and LLP is allowed or not. So this is the landmark case law, Messrs. Real Image LLP with Cube Cinemas Private Limited. So the merger was sanctioned under a provision of section 230 to 232 of Companies Act 2013, and the Chennai bench of NCLT noted the following while sanctioning the merger. So tribunal highlighted the fact that the merger of two or more LLP and company has been provided for in the Companies Act 1956. So however, there is no specific provision which was provided in Companies Act 2013. So therefore, this is a case of casus omissus. So further, it is inferred that if the intention of Parliament is to permit a foreign LLP to merge with an Indian company, then it will be wrong to presume that the Act prohibit a merger of Indian LLP with an Indian company. So, and there doesn't appear any express legal bar to allow sanctioned merger of Indian LLP with an Indian company. So the merger of foreign LLP is allowed in section 234 of Companies Act. So it states that if merger of that foreign company with LLP is allowed, then the merger with an Indian company of LLP also shall be allowed. So this is the conclusion that has been allowed in this case law, Messrs. Real Image LLP with Cube Cinemas Private Limited.
May I intervene? I think this matter has been dealt with by NCLT thereafter, and it has reversed this decision of NCLT.
Okay.
In I think 2020.
Yeah, this case law, but as regards NCLT, I have no idea. It is reversed now.
Is it?
Yes.
Yeah.
Yes.
Oh, that is the latest development.
It is the latest development. I don't know whether the same is pending before Supreme Court, but NCLT had reversed it.
Okay. Because when this case law has come, it was actually a landmark judgment. It was like
Yes, it was a
very highly
yes.
talked about it.
Yeah, everyone was talking that time, right?
Yes, and prior to this also there were two mergers which were approved by Mumbai bench and Ahmedabad bench, but those were not challenged. Here the ministry went ahead and challenged this order in NCLT and it was reversed. So there is a little gray area as on date. And I am not aware whether it was further challenged in Supreme Court.
So earlier there was a merger between company and LLP.
Yes, Mumbai bench and Ahmedabad bench had approved prior to this. But when Chennai bench approved it, the ministry went in an appeal. RD office went in an appeal before NCLT and it reversed that judgment of merger.
So it's in limbo, we don't know.
Yeah, because as on date, the law which would prevail would be the order passed by NCLT.
Right.
Then in which case the other merger which is approved, that also likely to be affected, correct?
I am not aware because those were approved and made effective also, sir.
Yeah, that is what.
So now it will not be, no, because this NCLT order will be specific to this particular.
Only specific to this, yes.
So it cannot be applicable everywhere, and everyone has to specifically, challenge and cover. But
yes,
you can take a clue from this, of course, NCLT judgment that as on today it is prohibited.
Yeah, as on date now the other offices will not approve it. No regional director, no NCLT bench because it is rejected by a higher appellate authority.
Higher appellate authority.
We not only wait and see whether any appeal is there with the Supreme Court or pending anything comes out.
Yes, I was also checking, but I didn't find that.
Okay. I think it is interesting to follow it up and see.
Yes.
Yeah.
Mm. Okay. Yeah, Keval, next.
Okay. Further, I'd like to add one more point of foreign LLP, which is prescribed under the LLP Act. Section 2, subsection M of LLP Act provides a definition for foreign LLP, which is form or incorporate or register outside India, but which has a place of business in India. So foreign LLP can also be formed in India and can have a place of business in India.
So it is foreign LLP. Can you repeat again? Sorry.
So foreign LLP is a LLP which has been formed or registered outside India, but which can have a place of business in India.
Okay.
So the LLP Act 2008 can be applicable to that foreign LLP as well.
Okay.
So now FDI norms are like a little easy. So if we want to appoint designated partner in LLP, means we have to appoint a foreign designated partner in an Indian LLP. Then FDI norm is like now as allowed 100% via automatic. So they can bring the contribution considering we have to follow the certain provisions of FEMA. So now it's easy to have a foreign designated partner in an Indian LLP, or we can form foreign LLP as well in India.
Not foreign LLP, LLP with the foreign designated partner.
Yeah, that is right.
Yes.
Is there any clarification about LLP, NBFC? You have idea? I don't know. But NBFC company only this is. Please carry on. It is dial only. But carry on this. It is NBFC company, not LLP. Please carry on.
Okay, so this is the end of my webinar. So I would like to thank Mr. Dipti ma'am, Bala sir, Neetu ma'am, Disha ma'am and Rupa ma'am for their support and cooperation.
Any question is pending in the chat box?
Yeah, I think there was a discussion going on as regards the consolidation of accounts of a defunct LLP, where you are holding 60%. If a company is holding 60% of LLP, the company required to consolidate account of LLP, but if that LLP is defunct, and what to do? And then it is said that since it is, you have to consolidate, even if it is defunct. It's a non-compliance.
Can I express my view, Dipti?
Yeah.
Yeah, please.
See, consolidation, particularly because you are saying it is a private limited company, so being governed by the Companies Act. So Companies Act makes it mandatory to have consolidated accounts if you have a joint venture, subsidiaries or associates. So that's why it is mandatory. Now, the question is defunct. Now, when I have taken a 60% stake, so it must be the functioning company. Otherwise, I would not take the stake. Now, let's say first year I have done a consolidation. In the second year, being defunct company, accounts are not prepared. Now, I being holder of 60%, I am the holding company. So I am building a lot of control on that LLP. So in the first instance, I should be able to prepare the accounts. And if not able to prepare, appropriate note can be given and we have to continue to consolidate based on the latest financial statement, which is a year back. But then we have to disclose why the latest accounts are not prepared of that company and impact of it any. So then it can have impact on the audit report also, depending on whether it is material, non-material, etc., etc.
Right.
But consolidation is mandatory.
The auditors will make a remark in the report that is LLP is having such status and therefore it is not taken in. Suppose in a private limited, if it is an unaudited result also, though it is not a defunct company, but the results are not audited, then the auditors make a remark in the report that this private limited company's accounts are unaudited and management has given a letter or the representation to that effect to the company, holding company and the auditor.
True, but here when we are saying companies defunct, accounts are not available. So even a management prepared accounts are not available, I presume.
No, so at least the auditors can mention this fact in their report. So they also want to save their scheme, you know.
See,
no, true. See, it will depend. Suppose this subsidiary is not a material. So then appropriate note can be given in consolidation saying that these two accounts are based on the earlier accounts. Let's say, I mean, if you talk about 21, and let's say 2021 financial accounts are not available, but March 20 accounts are available. So that March 20 accounts, you have to continue to consolidate, saying that 2021 accounts are not prepared, hence not included in this.
But then for how long you would continue like
I
this?
think it is not
No.
the correct way. Rather, I will say that, Mrs. I can correct it, that you can't consolidate it. Its account is not prepared. You have to give notes. What you
Of
can.
course, of course.
And you have to try to say that you have tried, you have taken efforts, but the same is not possible because whatever 30-40% is not supporting.
For say March 20, you can consolidate in March 21, same result. What about March 22?
Exactly.
No,
Exactly.
You can't keep on continuing 20 for 21, 22, right?
you are
There
wrong.
has to be a proper appropriate note to that effect.
Yeah,
No, no. In either case, note will be there. And second issue is you are a major shareholder, so you are a holding company kind of a thing. So you are controlling that subsidiary.
But still,
Even if it is LLP.
Many times it is not possible. No? Even though you are holding 90%, 10% also.
See, I think the
very
percentage doesn't matter. Even if you are it is an associate company holding 22%, then also the same principle should apply. Whether you are holding 60, 22, or more than 20, or even as Dipti Ben is saying 90.
No, there is a difference. If you hold, let's say 22, and when you are holding 60, see, you are controlling the subsidiary fully. That's why it is called subsidiary. When you are holding 60%, that means you are involved in the day-to-day functioning also. So there it is very difficult for you to say that company is not preparing. It's a holding company which is not preparing the accounts of subsidiary.
No, we are talking
That's
about
different.
whether the consolidation is happening or not happening.
No, company consolidation is mandatory. If it is not happening, as an auditor, person will qualify.
Correct.
He will qualify. At the most, there could be adverse. He will, on consolidation, he will refrain from expressing his opinion.
Correct. So that's what we are saying, or we are discussing. This appropriate note has to be there in the auditor's report.
Yeah, that
Yeah,
is right.
but
That is
sometimes what happens, being a defunct, let's say you have 20 accounts and there is no P&L, there are not much liabilities, maybe not much outsider liabilities, etc. So depending on situation and what is the percentage of that LLP's share in the income as well as in the assets, auditor can take a call. He need not put any adverse remark, but he will, even what we call it, emphasis of matter. He will just draw attention without qualifying. So it all is a situational call.
Yeah, normally they call it what you call emphasis on matter.
In Italy, they will give that this thing.
Now let me share some actual example which we have come across. Assuming that LLP is incurring losses and your net worth has become negative, etc. So what happens in the standalone? Whatever investment you have made, 60%, let's say you have invested 100 rupees. So in the standalone account, you make a provision of write-off of all the 100 rupees. Accordingly, that you can mention that company is now defunct and assets are lower than the liability. Liabilities are more than the assets. So not a going concern, being defunct, etc. And that's account not available and not consolidated. But as far as on standalone basis, whatever amount you have investment has been fully provided in the standalone accounts.
Yes.
And also in the consolidated based on the previous year account. So when you do consolidation, you account your 60% share in the profit loss, everything. So your investment in consolidation has also become zero. And not being material, then you can, but you have to mention that facts. The reason that accounts are not available or whatever the reason for non-availability and company has stopped functioning, etc. You can mention that. And qualification will again depend on the percentage of its impact on the consolidated accounts. If it is not material, then auditor need not even mention about it. If it is little material, he might draw attention like emphasis of matter. And if it is still material, then he might qualify the report.
Simanti, you had some question, I think so. You raised the hand.
Yes.
Yeah, please.
Hello. Yeah. Am I audible?
Yeah, very much.
Yes. Yeah, I have two questions. One is about this defunct LLP. if the LLP's purpose is, it's like a shell LLP created to save the brand, the name, and other income is getting generated, like there are FDs and investments kept, but as such there is no business. Will it be still, and returns, everything is getting filed regularly, will it be still considered as defunct LLP, like not functioning?
No.
No, right? Okay. Fine.
Next question.
Yeah, my second question is for deciding a structure, most of the points were clear that LLP is low on compliance part, but when it comes to now, even manufacturing is allowed in LLP, but is there any scaling up restriction? Like no one would prefer to go for a structure which is, high on compliance, especially if FDI is involved. Then is there a limitation or a restriction to scale up? Like I cannot, be in a manufacturing setup with the LLP structure, and then I have to mandatorily shift or move to private limited or a limited company structure.
So legally, there is no restrictions on LLP to scale up the activity, but there are certain unwritten laws. Like as you are mentioning, if your LLP is into the manufacturing, and let's say you have a capacity, installed capacity X, tomorrow you want to make it to 2X. Now it depends how you want to scale up your activity. Let's say you want to go to the bank and borrow. Then banks have unwritten law. They will say no, beyond X amount, they would prefer a company under the Companies Act because it has a permanent existence compared to LLP. So, for example, I am a banker. You come to me for a financing. I'll say you convert your LLP into private limited, then I'll fund you. Now, assuming that you have partners are ready to chip in the money, then you don't have to go to the bank. So you can scale up your manufacturing facility. There's no restriction as such.
Okay, as such, if investment is not an issue, borrowing or funding is not the issue, then as such, for running hardcore manufacturing activity, say, waste to energy or any startup coming up in renewable energy, hardcore manufacturing, proper factory setup, everything, and LLP can work, right? I can scale it up to any extent, provided funding the investor, the core partners are bringing. Then there is no legal restriction as such.
There is no legal restriction. There is no legal restriction, ma'am. But if you want your scaling up activity, etc., to go on for a long, the only hurdle I see here is from the income tax angle. From income tax angle, LLP is treated as a partnership firm.
Correct.
So today, let's say you and me both are the partners of LLP. Tomorrow we want to induct Llp also into this. Then, and having, let's say we have reached a turnover of 100 crores, then matter will totally get complicated. How to get Llp into the LLP? Because for partner, from income tax angle, it is like introducing a partner, transfer of assets involved, undervaluation, overvaluation, and all kind of problem can come up. But all these things will be little smoother if it is a private limited. So there is no written restriction as such, but you will face a lot of hurdles from income tax angle, because in income tax, it's still taxed as a partnership.
Okay, understood. See, for individuals, I can understand bringing more DP, but suppose a structure is there where two body corporates are the partners, and the funding is coming. Everything is transparent, whatever. One is in Switzerland or in Germany, and they are investing. Proper body corporate structure, a nominee partner, Indian partner, one foreign, and it's running, and they really want to scale it up. Is it still possible, or the income tax will become an hurdle in itself?
Not at all. Income tax will not be a hurdle.
Income tax will not be a hurdle, because as he rightly said, it is when you go for the borrowing, etc., and all this thing, they don't want to encourage LLP, they want to go for the company. From there only it will come. Otherwise, it will not. Law does not put any restriction for scaling up.
So another hurdle in your case, if you are saying you have both the partners, both both the partners are, let's say, from out of India, and assuming this is a FEMA compliant also. Now let us look at from income tax angle. It will be treated as a partnership. So firm will be means LLP will be taxed in India. Now we'll have to look into the DTA. Otherwise, because then this will become again an income for the partners in their country. So looking at the laws of the investors' country could be different. In many cases, they treat once it is taxed here, need not be taxed there. And in some cases, it could be. So tax directly, indirectly could be a hurdle once it grows beyond the size. Whereas had it been a private limited, it was clear, unless dividend is declared, it is not an income for the investor. So you can accumulate the profit, keep on expanding. Here, even if you do the same thing, still tax issue could arise.
Yes, okay, understood. I got my answer. And just one input I want to make. I faced one challenge. The way accounts are made, you know, as per accounting standard for this LLP, the profit gets merged into the capital, you know, a basic thing. And when I received those financials, you know, to file up with the MCA form, my form 8, then the form was asking for the split, you know, original and the reserves part. So as such, when a partnership accounting is done, the reserves are not there, it got merged, you know, basic concept of partnership. And then it created a confusion at a group level. I'm just sharing my experience. They said how a contribution can increase in a structure when no funding has happened from the group. And then it took a while, you know, for me to explain that this is the way the accounting is done in India, where the profits are shown as, you know, clubbed way in the original capital. And from that date to resolve this, because obviously I cannot change MCA form, I started a practice of giving an elaborate note in notes to accounts, giving that bifurcation. So I'm then meeting both the criteria. One, my basic principles of accounting, how a partnership accounts are maintained. And second is my MCA requirement, and then to answer any further query. That there is no further FDI or contribution, but it is just, you know, plowing back of profit.
No, here, ma'am, you have a very simple solution. In the LLP, when you prepare accounts, let's say you have started LLP with 1 lakh rupees. And both the partners have contributed 50,000. So call it a permanent capital, and it will remain 1 lakh forever. And then whatever profit you credit, you create a current account. So in the year 1, you have a profit of, let's say, 60,000 rupees. So credit 30,000 to both and credit to current account. So current account total of both of them is equivalent to your reserve. So that sorts out your problem.
Another way solve the problem. Okay. I just, because, okay, as usual in my setup, the finance said, no, we'll maintain it in this way.
Still, you reset your capital into 2, permanent capital, which is the original contributions and the same ratio. And second one, you call it a current account. And tomorrow, if they bring in some financing, then you call it a loan from the partners. So A brings in 30,000, B brings in 50,000. Which will be eligible for some interest, etc. So that you call it a loan from A and loan from B.
Got it. Okay.
Better suggestion. Yeah.
Yes, sir.
Okay. All questions are over, I think so.
Yeah, you're right.
Yeah.
My one question, Dipti, if you can share PPT with the participants.
Yeah.
That will be shared. There is no problem. That will be shared. Mehta will be sharing it. That's not an issue.
Yeah.
Thanks. Thank you.
Mr. Mitesh, you want to add something? Mr. Mitesh? Mr. Manish, you want to add something on your part?
No, ma'am. I'm done.
Okay. In that case, I thank both the invitees and Mr. Mitesh and Mr. Manish for their time, and of course our own Mr. Bala for their contribution and their time and inputs, and all the participants for their active participation. Thanks a lot. Still, if you have any questions or all that, you can send it. We can take up in next session also. And you can suggest the session's topic that will be helpful.
Let me also thank to Keval for his excellent
Yeah.
preparation, although there were technical hiccup here and there. Anyway, that happened, that is beyond his control. But he has done a very good job. Let us recognize that also.
Right.
And ultimately, thanks for the participants also, because the participants were very active. They were very interactive. Session has actually, even before the session started, they made it interesting. So thankful to them. It is definitely a knowledge adding session, I would say.
Yeah, thanks a lot. Thanks everyone. And
Thanks
keep-
a lot, everybody.
Thanks.
Have a weekend.
Have a happy
Thank you.
weekend.
Thank
Take
you.
care.
Have a safe and
Thanks.
Llp.